We're very lucky this afternoon to have Mark Fang once again as our speaker. Mark will address Westchester County's recently passed source of income legislation. In terms of background, we have a brief overview. Mark is the Executive Director of the Westchester County Human Rights Commission. He was appointed to that position in May of 2012 by County Executive Rob Astorino. A practicing attorney for 19 years, Mark has served as an Assistant Attorney General in the Criminal Division of the New York State Attorney General's Office. He has also served as an Assistant District Attorney in the Westchester County District Attorney's Office, the first Asian American to be appointed to that position in the county. The Westchester County Human Rights Commission works to eliminate discrimination and promote equality by advocacy, educational programs, and, when necessary, legal measures. The county's human rights law prohibits discrimination based on a wide variety of reasons. They include race, color, religion, ethnic background, creed, age, gender, sexual orientation, or disability. Those areas, of course, will be covered by Mark in his presentation. Mark is a Phi Beta Kappa graduate of Tufts University. He received his law degree from the Georgetown University Law Center. He has been in the private practice of law since 2000, where he has concentrated on litigation in both criminal and civic matters. He is a former board member of the Westchester chapter of the Organization of Chinese Americans. Mark is originally from Yorktown Heights and is a graduate of Yorktown High School. Please join me in welcoming Mark Fang.
Okay. Well, thanks for having me again. I was here maybe 7 months ago.
Yeah, about that.
We were talking about something. But I want to thank my ex-colleague Carl Finger for arranging this for me. We were colleagues in the DA's office a while back. Today we're going to get right into the law, the new source of income law, source of income legislation, which became effective in December 2013. So it just became effective. It was enacted, passed by the Board of Legislators, had a whole history that you probably know and that Jeff was involved in and Al was involved in with the Board of Legislators and the county executive, and lo and behold, we have our law. The law does expire in 5 years, so as I'm telling a lot of different groups, we should be taking notes about it and seeing what works, what doesn't work, so that 5 years from now, if it comes up before the board again for deliberation in terms of renewal, we can have some input and constructive input on what makes sense, what doesn't make sense for the law moving forward, if in fact it gets renewed. But we can be part of that process, and we should, 5 years is going to go by real quick. So there's not that many jurisdictions that have a law like this. So I've been looking at local enforcement of Local Law 10 in New York City, just to kind of guide me to some of the issues that may come up and how the courts have handled them. I can tell you some of those cases, maybe in the question and answer period, and I'll tell you about some of the scenarios that come up. I'll run through the law, just some of the basic provisions. That won't take too long. Maybe I'll go over some of the issues that come up or that I've seen in the course of other cases in the city with Local Law 10, and then we can do some question and answer. I have a copy of the law if you want to. I'll pass it out. I don't have 50 copies. Just start in the second section. But the first page, I don't know why we included that, but it's just the legislators that voted for it didn't vote for it. If you may find that interesting. Okay. So you can follow along with what I'm going to do. I just go through the law section by section. There's not that many sections. Basically, though, what has happened here is, in Jeff's introduction, we handle discrimination cases with the traditional group of group identities, and it's kind of an expansive list here in the county. But the usual ones: race, religion, sexual orientation, gender, ethnicity, national origin, creed, disability, of course, is a big one. And now, so with this new law, just so you can think of it conceptually, we've added source of income. So source of income is a protected category within the fair housing law, and then there's some exceptions. So I'll go over that now. Everybody get a copy here and there, every table? Okay, so just starting here, you'll see Section 3, source of income, not just Section 8. Section 8 was the primary purpose of the law, and you'll see in the preamble and the legislative history that was really the impetus for the law, with HUD really kind of putting a gun to our head to make sure that we have the law. So Section 8, but it could also be any other federal, state, governmental voucher, or non-governmental. So it could be something from WRO or Mount Vernon Tenants. Let's say they had a grant to give to their clients for housing. You'd have to accept that too. So it's not just Section 8. That's the point that needs to be made there. It could be a grant or a loan program from a private housing assistance organization. Section 3V1, just moving down again. So that's kind of like this is probably the provision that maybe Jeff and Al probably helped to work, make sure got into the law. And this is make sure you get the basic protection traditional protection for screening out prospective tenants. So you'll just note there, I'll read it since if you have it, you don't have it. For the purposes of this article, as they relate to unlawful discriminatory real estate practices on the basis of source of income, it shall not be considered discriminatory if differentiations or decisions are based solely upon factually supportable objective differences in the level of the individual's income. So that gives you, right, so the key word there is level, right? Level of income versus source of income, right? If you'll never be, you'll never have run into a problem with this law if you're genuinely looking at the level of income. Okay, that's what that's saying. And then just reading down, the level of income of the individual's income, which is defined as the sum total of all sources of lawful and verifiable income, including but not limited to the sources of income defined herein. Differentiation or decisions based on the level of income must bear a reasonable relationship to the individual's ability to meet his or her personal housing payment obligations that arise from the tenancy, ownership, or occupancy, etc. So, that's kind of like a litigation pressure point right there, right? Reasonable, does the rationale you gave, does it bear a reasonable relationship to the individual's ability to meet his or her personal business payment? Your lawyer will say it does, of course, and then the other side will argue that it's not reasonable. Okay? Moving forward, this is an important part, Section 2, on the following page. You're allowed to, you and your clients are allowed to inquire about what their source of income is. So they may make a written or oral inquiry concerning the level of source of income. So that's express provision in the law. They're allowed to do that. This next section are the exceptions. It's very important to remember the fair housing law exceptions, the original fair housing law exceptions. So you have, for instance, the Mrs. Murphy exception with the 4 or less home and the owner's in there, right? That's accepted from our law. Or you could own 3 single family. You're allowed to have 3 single family. This came up, and I was talking to Houlihan Lawrence, about whether or not that would be, so you have 3 single family, up to 3, as investment properties. You're not living there, but that's an exception in the law. Okay, a regional exception. So the original exceptions apply. You have to look at those, or have your lawyer look at those too. They're kind of grafted on to the exceptions here. This paragraph, which is, if you're following along, the parenthetical 3, V3. So this is one that gets confusing. So 700.21c, that's in the original fair housing law. We can talk about that, or you can schedule a meeting, and we'll go over those with. If you have any questions about those, I can walk you through those. A little bit confusing, but here's the new exceptions here. D, you're accepted from the law for housing accommodations other than publicly assisted housing accommodations for 6 or fewer families living independently of each other, provided that the person owns or has ownership interest in only one such housing accommodation. So that's a little bit confusing. So 6 or fewer. So if you have a 6-family unit building, that's exempted. You don't have to live there. That's exempted from the law. If you have 2 of those, then you're in the law. You fall in the law. We can go over that in the question and answer session, but it gets a little bit confusing. Because then you also have to graft on the, like I said, the original fair housing exceptions. Remember, so there's 4 or, I know, confusing everybody, did this yesterday. If you're 4 or less, a 4-unit house, that's the Mrs. Murphy exception. So that might not be counted in this 6-person total, units of 6 or less. We can talk about that, but that's one of the exceptions. So you need to think about the exceptions, right? See if the law actually applies to you. But that's one of the ones that you need to look at. If it's a 20-person unit, then 20-family unit, then you're not, you know that the law is going to apply to you. The next section 4, and this is the Lewandowski kind of rationale. It's expressly put into the law. This is probably what you guys helped to work on to make sure that it was in the law, and that's just to make sure that that this does not upset the reasonable business judgment rationale, the normal reasonable business judgment rationale for accepting or rejecting a prospective tenant. So they make that express. Section W, at the bottom of the page, it applies to all sale, rental, lease, sublease, just the whole gamut of transactions. We're almost done. So then you'll see the second to last page, section 6, the different the damage structure, the fines that can be leveled, and it can be very severe if for very purposeful, devious, willful, wanton, malicious behavior. And I'll just say that the law is brand new, and we know that. It's not. It's not an intuitive law. Like an assault or something. That you would know that this is a bad thing. There's a lot. For my presentations like this, a lot of landlords have very good rationale historically for not taking Section 8. But now this is the law. So I guess my point is that. We understand that the law is new, that it may be something that a lot of landlords and owners don't understand and need to become accustomed to over time. And that's how we see the law when we look at the enforcement picture on a case-by-case basis. So if we do see, obvious attempts to get around the law, or as I saw in one case relating to a city case, disingenuous arguments to support your rationale for rejecting a Section 8, that's one category of a kind of case that we would look take very seriously and look very hard at. If it's another case where, this is brand new law and, this has just had been your business practice, but now you had been unaware of the law and you had come across a Section 8 applicant and, unbeknownst, without knowledge of the law, and we had determined that was really the case, then that's another category of case. So I just want you to be very certain that we're going to be very reasonable in the enforcement of the law, as we are reasonable in enforcing all of the provisions of the Fair Housing Law and the Human Rights Law. And then that's it. You'll see in C the sunset provision. The local law shall expire, so it automatically expires and be deemed repealed 5 years after the effective date of subdivision B of this section. So I don't know what happens after 5 years if some legislator brings it up. I guess it'll probably come up 3 years from now or something, and then this whole process of getting it renewed will take place. But by then, hopefully we have some experience with it. I was just talking to these guys back there about dealing with CVR, which is the administrator, and that sounds like a good idea, just to get kind of a knowledge of the Section 8 process. I can just tell you from some of the cases I saw, courts haven't looked at the excuse of a couple landlords tried to use the excuse of, my place wouldn't qualify anyway. It didn't have the right sink or something like that. And courts said they weren't sympathetic to that. They said, that's not your decision. That's based on the process set forth in the federal regulation. That's the administrator's decision, not me. It would be in our case CVR. So that's an interesting category of cases to look at. That's actually it, right? If you have it in front of you, that's the whole law. And I know you have some questions probably. There might be some hypotheticals, and those are very difficult for me to go over because eventually, I'll have to make some decisions on individual cases, and I hate to be locked into, back then you had said that you would come out like this on this kind of situation. But I guess I'm open to questions. Oh, that's fine. Okay.
Okay, I want to get clear the issue of the level of income.
Mm-hmm.
And or let's start with, like in Section 8 cases, what do we ask for people? Historically, I'm taking Section 8, but I'm really for people who are working.
Working and Section 8.
Yeah.
That's an interesting distinction you make, right?
So if I basically, hypothetical, if someone came in with DSS in Section 8 or working in Section 8, my preference would be to take the one that's working in Section 8. That's part of that category having to do with your business judgment.
Yeah. Right.
For years,
Yeah.
Would that be considered discriminatory according to this law?
Yeah, I wouldn't give you enough thumbs up or thumbs down today, just in this presentation, just because I don't want to. I'm going to get cases, live cases, so I don't want to be locked into anything. But what I will tell you is, what you're articulating now is a rationale other than just the person's source of income, just based on what you just said to me. And, you know, it seems like that's possible that that may very well fit into one of the reasonable business judgment rationales.
Did you find any, I've got a whole series of questions, so.
Oh, yeah, that's okay.
Somebody does that with it.
Well, I'm 3 hours, right?
In the case law where,
Was it a local law 10?
where they use the business judgment and where
Yeah.
that would give us some guidance in terms of how far we can use business judgment. Because
Yeah.
those of us have been landlords for a long time. When it's a question, you bring them in, you start talking to them, you get a feel for them, and then make a decision.
Yeah.
And, you know, you don't put a number on that. How is that going to be in front of the...
Like gut feeling, or?
Yeah, that's right. In other words, it's my gut that ultimately decides whether we rent it to this person or not. And you get in front of the Human Rights Commission,
Yeah.
and they'll say, you know, how do we, I don't know what criteria you can use.
I know, I mean, I guess I would have to look at and see what the other factors are in tandem with your gut feeling, and also see what the other side has to say about that. You know, what they may, how they may be able to shed light on what your real gut feeling is. And I guess that's the kind of case that would be, you know, maybe a fact finder would have to determine. But if it's just, if you just said,
At this point, you can't give us guidance in terms of how we do it until...
well, I think I gave you guidance on the first situation you said.
Yeah.
If you listen to what I said, right?
The question about level.
Yeah, because you said you had source of income, and also what was the other thing? Yeah. So you know, that's to me that is sounding along the lines of a reasonable business judgment.
Right.
When you now you ratchet it up a little bit and you say, you know, gut feeling in any fact scenario where we see gut feeling, whether it be like an employment case or a public accommodation, you know, case where the person, you know, had the owner of a store had a gut feeling about the person and stopped them to see what was in his bag. You know, gut feeling doesn't. We probably have to sift through the gut feeling.
So, and maybe another question that has to do with, sometimes these cases have come up a year or two later. If it gets to the Human Rights Commission, how much documentation do we have to do? You know, we have an application, how long? We have to document, we decide not to accept somebody, exactly why we didn't do it, and be able to resist.
Well, if you have contemporary, in any law setting, right, that if you have contemporaneous documents that you can present when, you know, something hits the fan, that has a lot of weight. When the investigative agency is reviewing what actually occurred, right? So,
what if somebody calls our office and gets turned off, said, we were discriminated against, that was it. They didn't fill out an application, didn't do anything. And a year later, they come in and accuse us of discriminatory practice under this thing. You know, how are we going to handle that?
maybe you
We
got
have documentary telephone calls, somebody is looking for an apartment.
Well, you know, if the person coming forward with a complaint has to have some, you know, has to have some articulable basis for making a complaint. Right? We're not going to take every complaint. So if they just made a call and said, and were rejected, then that's going to be in the factual mix too. And that's not, maybe won't have as much weight as if you know, walk through the application with the process through the, you know, for several weeks, and then they were rejected all of a sudden. So I think that this doesn't change. This shouldn't change how you run your business in terms of what your document retention policy is, or whether formal or informal. These cases could always come up, even if there was no source of income law, right? You could get challenged for a racial issue or ethnicity. So this doesn't change how you're going to do your business practice in any dramatic way.
More, I think it will, because it's fundamentally different question. It has to do with,
It's going to change your document retention policy?
yeah, social practices as opposed to questions.
Yeah, no, I think it'll change a lot of things like that.
I think so. And
But how you run your business and what your internal policy is in terms of keeping records of things, I don't think this is going to be any more strenuous, other than now you have another category that you have to look out for.
is there a limitation on, is there a factual limitation on this?
Well, 1 year for us, meaning,
In other words, they have.
Let's say it happened-
Within 1 year.
yeah, within 1 year of the event.
Okay, yeah. All right, maybe next, I have more questions.
Okay.
Please, I want to.
Judge, Carl Finger, Carl, you can go, Judge, just jump on the phone, you
Can you just walk people through the process, in brief, the process, when a complaint comes into your office? I think that would give some context to some of the questions that are being asked, so that people understand, how that works.
Yeah. So, and this is kind of new procedure that we've put forth, but, so the process for us is the person walks in the door, or they call, they email with their complaint. We won't file a complaint immediately. They have to really cross a threshold. So a low threshold, de minimis, as they say it in the law, but they have to have set forth something. Can't just be, I was discriminated against. So if they're able to articulate a prima facie case of discrimination, whether that's employment, housing, or any of the other categories, then that's enough to file a complaint with the Human Rights Commission. We then allow, this is new, we'll inform the owner that we have enough to file a complaint. The person we believe has set forth a prima facie, is able to articulate. Doesn't mean it's, the case is decided. It's able to articulate a prima facie case of discrimination, housing discrimination in this case. We then allow a 20-day window. This is our new procedure. 20-day window for the two sides to see if they can work it out, negotiate some kind of settlement pre-complaint, before we receive a complaint. We'll get involved in that, but hopefully the sides can, if they can work it out, sometimes these cases can just work out with the pressure of a pending complaint before them. If they can't work it out, then we'll file a complaint with the commission, and then the investigation will proceed like a normal investigation for any other case, and then we will try to make a determination of probable cause or no probable cause. If we determine that there is probable cause of a violation of our law, then the case will go to an administrative law judge for a fact finding, like a mini trial, and then the ALJ. We have 4 ALJs. Actually, Carl's one of them, who will administrative law judge. So they're like judges, but they're administrative judges. It's like hearing officers, or, a DMV or something. So then they'll decide. They'll hear witnesses. They'll look at documents if you have them, and then make a decision. And then they'll come out with a decision. They'll also determine what they believe are the damages and the applicable fines, if anything. Sometimes they'll be fines. Sometimes they may be equitable relief. So that's how the case plays out. And then there's an appeal process. Ultimately, the case could go to the second department, the Supreme Court Appellate Division, second department. So you want to also be guided by their law. When I say that, I looked at some local law, some cases in New York City. You just keep in mind that those cases are always going to be more pro-complainant because of what was called the Restoration Act. The New York City law, just as an aside, I'll tell you, is much more vigorously enforced than or vigorously interpreted than other laws in the state. Okay.
Jesse, you're up.
Quick question. I know this law is, like good for 5 years. Just curious about statute of limitations on this. In other words, it's 4 years down the road, someone decides to come back 3 or 4 years. Is there any statute?
Well, for us, you have to come, and this is in the mainline law, the mainline fair housing law and the human rights law. It's a 1-year statute of limitations. So if it occurred 5 years ago, too late.
Yeah, we go folks.
Yeah. Yeah, that doesn't change. Yeah, that doesn't change. Yeah. Oh, thanks.
Ken Baker.
Mark, you mentioned just now possible equitable relief after a hearing. What type of equitable relief would the commission have the jurisdiction to impose and enforce?
Well, a simple one, maybe the person, we may ask the person to be reconsidered his application, or that his application be accepted, something like that, right?
You think
Or there could be like training requirements that we've imposed in different cases here and there. Yearly training requirements on the fair housing law.
Alan Singer.
Yeah, I'm a little concerned about how one can force a landlord to do business with HUD, which is, as we all know, one of the most unreasonable and obnoxious agencies that exist. And you're forced to accept HUD's lease, you're forced to accept HUD's determination whether you can terminate tenancies, and have to be subject to their regulations and to their inspections. And has there been any case that says that there is an ability, constitutional ability to force a landlord to do business with an agency you don't want to do business with?
Yeah, I think there has been. I'm not a HUD defender here, and I just enforce the law. But I think there has been. I think that bridge has been crossed. There was an interesting 1998 Second Circuit case that dealt with this, that made it seem to me like that this might not be constitutional. But I guess that I was wrong, because we're here, right? We have a law. It's all citizens in other parts of the state. I think Nassau has it. Nassau has this. So I definitely understand what you're saying.
Yeah, it's one thing to say that you have to accept HUD's money. It's another thing to say you have to be subject to all their regulations.
Yeah. I think mechanically, there'll be issues that come out about how this is enforced and how it's interpreted against people along the lines of what you're saying. Mechanically, we'll start to see that, and in a few short years, those issues should be brought to the attention of the legislature when they think about renewing the law or revamping it.
Our friend from Hayward. I'm sorry.
Oh, that's right. Yeah.
Go ahead.
One of the conflicts that Long Island has had with their sources of income protection rules has been the fact that Section 8 and numerous other government programs require the approval of the property, for the program, which can take months at a time before you get that. So the question becomes, if I've got two tenants, one that's able to occupy today, and one that I have to wait until I get through the approval process in the program, is it within my reasonable, my reasonable judgment exception to say, I'm going to take the guy who's paying cash because he can start today, and I don't have to wait 2 months for another approval.
Right.
Is that within my reasonable business judgment under this law?
I like that one, but I have to. I don't know what my instinct is. I guess along the lines of your instinct, but I have to look at the way the courts have interpreted that kind of thing.
I don't think they've handled it yet in Nassau.
Yeah.
So,
They had a problem. Nassau had a problem because that's why they're not. Barry knows this because he was involved in the Human Rights Commission. He was the chairman of the Human Rights Commission when the Fair Housing Law got passed. They actually, Nassau because, I think it might have been because of the source of income, but they are not a partner with HUD like we are. Because of some issues like that, they rejected it. So they do have a Human Rights Commission and fair housing law and all that stuff, but they said because of some kind of problems with the law like that. So, yeah, I'd have to look at the way the courts interpret, but I mean,
Some of the biggest problems we as an industry have aren't necessarily with the tenants or where they're getting their money from.
Yeah.
They are with the governmental process, which is so burdensome as, we're not discriminating against the tenant or where their money comes from, we're discriminating against a governmental program which is really putting a burden on the landlord.
Yeah. No, the only strain of cases I saw along those lines, is like I said before, I briefly said before, are the ones where the defendant said, they said, no, we wouldn't pass muster in the Section 8 process anyway. They did their own judgment. So that's a little different.
Yeah.
And the court wasn't sympathetic to that. They said, you don't make those decisions. The administrator does. In our case, CVR. In the cases I read, was NYCHA. So that got smacked down. But yours is different.
Yeah.
Yours is different.
Could a landlord, for instance, say, yeah, I'll accept this time, it's going to be on my lease, not your lease, and no, I'm not going to go to the trouble of recertifying, and that's your business, and if you don't like it, then he doesn't get this apartment.
You mean reject the Section 8?
Yeah, reject this, it's not going to do that.
Yeah, but then the person can't pay, right?
And if I has to come up with a different method.
Yeah, see, I guess that would be kind of, that one might run you into some trouble. I don't know. I'm not here to make judgments. Right, because ultimately you're kind of rejecting the law. And
Maybe the law needs to be rejected.
it will be civil disputes.
Mike, Johnny, and then everyone will show. Mike, go ahead.
Or following up on some of these more recent comments, the process, you get the application review, you use your business judgment, not accept the staff. How should we close that out? Should we notify them, the prospective tenant in writing that we aren't going to entertain their application for X, Y, Z? Should we email? Should we call? What constitutes a good procedure to kind of tie that loose end, I guess?
For Section 8 or anything, right?
I guess in general, because again, we're going to treat everybody the same right now.
Yeah, I'm not an expert in that kind of landlord management question, but I mean, you would know better than me, Carl. But these guys are, there's a lot of tenants who who are, they know their rights and they're ready to jump. So it seems to me anything you want to do to protect, to make sure that something creeps up, like you're saying, down the line, 9 months, 11 months down the line, and you've got something to show, right? Because there's some viable claims, real claims, and there's some all the way down through the spectrum to frivolous. And if you can show something, contemporaneous records that can put that to rest, that's always has a lot of weight in any legal category, in any legal kind of case, right?
So then it sounds like you should use some form of notification of the person that you're not going to accept their application.
I don't know. I think that opens doors too. Then what are you going to notify them of? But a lot of times if they're, I don't know. It's different ways to look at that. Sometimes when you notify them, then they feel like they've been treated with respectfully, and then they were able to handle it. Sometimes that just starts the process for them, and they start to wonder what had happened, and it initiates something. I don't know what the best practice is. Probably notify, right? And these guys know.
If you have something in writing, then you can rely on that later.
Right. Yeah.
Of course, the co-ops have protected themselves for years by never making a disclosure about why they reject.
Exam copy from Claus Cato's exam.
Oh, I forgot to. Yeah. Oh, shoot.
Protected themselves from rejecting applicants for years by never disclosing.
You have And we're still fighting.
Yeah, I forgot to say the major exception in the law, which is it doesn't apply to co-ops and condos. So,
That's, yeah, but I meant with regard to whether or not.
yeah, but I just want to make sure I say that, because that's a major exception. If it's a co-op or a condo, it's not included in the law.
That's what's wrong, you can wait, thank you.
I have two questions. The first one has to do with how to figure out the level, I think it's getting goes to the level of question, which is, if a landlord has, let's say, numerous apartments, and they have a protocol and criteria in place for renting those apartments all these years, let's just say they rent to somebody who pays have to pay more than 40% of their income in rent, and they won't rent this to someone whose credit score is below X, and that's been their criteria for all the years. Are they now going to be forced to change that? Even if you consider, let's say, the Section 8 income, and it still doesn't rise to 40%, if that's the landlord's criteria, is that landlord now going to be obligated to back up what he's been doing all this time? If we can substantiate that that's his requirement for it?
You're saying 40% rent to income ratio.
In other words.
Oh, I see. Oh, yeah, I see what you're saying. Right.
40%
Yeah.
minimum credit rating.
Right.
X credit, let's say 600 or 650.
Yeah, well, the credit is, to me, that's purely level of income and, right, a business judgment, that's squarely. I can't see how that, actually, I was in a tenants association meeting yesterday, and they said they had problems with that. And then the other thing, the level of the source, the ratio, that also, to me, looks like a purely business judgment.
And say no felonies in your history, no evictions in your history.
Well, that would run afoul of the state law. I think that might, I don't know if that applies yet. At least for employment. We don't have that in our law, but, huh?
All right, well, that makes me to my next question.
Or evictions.
Well, you can have a criminal record. There's protections for people with criminal records. Not in our law.
All right, well, that leads to my next question, is we're talking about statute of limitations of this law, or, just investigation by the department. If a person who feels that they've been discriminated for source of income requirements, also file a case with the New York State Division of Human Rights, or bring a legal action in the court of law for discrimination based on that fact alone?
Source of income?
Yeah.
No, because the state doesn't have it.
So it's just Westchester.
Right now, yeah. If it was the city has it, we have it, Nassau has it, right?
They can't allege
Nassau has it.
a cause of action to any other higher agency than the Bureau.
No, I think they could. So in other words,
Could they go
but they couldn't go to the, they couldn't go to the state, but they could go to the court. They could go to a New York State Supreme Court, and they'll interpret our law.
and they'll interpret?
Yeah.
So they could still sue in court?
Yeah.
They could sue under federal fair housing, civil rights action in federal court?
Yeah, if they have if there's some basis for them to be in federal court, maybe there's like a HUD, a FHA, Federal Fair Housing Act, that might be one of the causes of action, and then another cause of action could be this one.
Based solely on the source of income, not if there's any other kind of discrimination or anything else, just say, I was discriminated.
Yeah. So look, you could go to here, you could go to state Supreme Court directly, or you could go to if you can get into federal court, you go to federal court.
Yes, sir. Let's say at a certain level, income level, or credit score level, I decide now I want to increase that level across the board.
Mm-hmm.
And all of a sudden then somebody now challenged.
Like increase the ratio, or increase what?
Yeah.
What the level? Yeah.
Well, 500
Yeah.
credit level, 600 now increase to 700, whatever.
Yeah.
and I want to do that across the board, and I've never done it before, then I start to come forward. How would your office look?
I mean, if you have a rationale for doing that, a business rationale, reasonable judgment, then I think that passes muster. You know, if we got this email, smoking gun email that said, you know, oh, I'm going to increase the credit score because we did a study and that'll eliminate most source of income. You see what I'm saying? Then then I can't ignore that. Yeah.
Level protection.
Yeah.
In terms of
because you know why? They'll make that allegation. You know what I mean? Someone will, you know, anything that you could conceive will eventually, if you get the right, you know, complainant, it'll come to the fore.
Would it make sense, let's say I go in and I want to change policy,
Yeah.
and I send it to your office. Would you accept the policy statement going showing that so this way later on, if somebody came and claimed it, you would have a record that showed what we did at any time?
Yeah, that's interesting. There's some kind of debate about whether or not we could do something like that. I mean, look, my coming into the job, one of the things that they, the county executive, Rob Astorino, and his staff wanted me to be wanted to be clear with me is that we're not here to overburden employers, business owners, builders, landlords. If there's a violation of the law and there's discrimination, we're going to really enforce our laws. That's what they're there for, and we have a duty to enforce the laws. But we're not here to, entrap people or, make cases. So we're going to be fair. So if you have something like that, maybe we'll, take a look at it.
Let's be proactive.
Yeah, that might be good. Good way to have a kind of a relationship, right, with the different entities, because that will, it's better to be clear, right? That way, I think it might be a better way. And people know it's good for you to know the law and be certain of your obligations under the law. So.
We have time for two more questions. Paul Milvain first. Do you anticipate going forward that your agency will provide better, clear guidance on reasonable business judgment or absent that unreasonable business judgment? I mean, this kind of ties into what you're suggesting.
I could give a seminar on that if you want with Carl what I would be doing is reviewing the cases, maybe some of the cases that we handled and what the outcomes were, and maybe some of the second department cases, interpreting reasonable business judgment. I could do something like that and tell you what the courts have said is reasonable business judgment.
Where do you get our guidance from the decisions that the courts show?
You can get them online. Where you can go, if you put in reasonable business judgment, I have Westlaw, but if you went to Google Scholar, you put in reasonable business judgment, you put in New York courts, you'll see a whole bunch of cases will come up. And they'll say, it was a reasonable business judgment for the person to consider credit and have a ratio of this, that, and other thing. And then they'll articulate for you what the different standard factual predicates have been in different cases and how the courts have interpreted it.
Go ahead, answer.
Yeah, I was honestly trying to get your opinion. The one thing you said about level of income, the 40% rent to income ratio scenario. I know there's a case in New York City that came out of that and said that it wasn't allowed, basically because it's the same language we have in it, that says the differentiations on level of income must bear a reasonable relationship with the individual's ability to meet their personal housing payment. So it can't be level of income, is what the court has said. It has to be their ability to pay the amount due. So what you have to do is compare literally, if you've got one person who doesn't have any kind of voucher or government aid, their ability to pay the full rent as compared to the other person's ability to pay the remainder of the rent after the voucher. And that's what you have to look at. So if
Was
that's
that
the
it?
case, you can't just use a flat 40%. You have to use a percentage of what's left of the rent after the assistance program, which of course raises the next issue. How
Who's that? Was that a-
I have to say what you just mentioned, Googling.
Who was that, in New York City?
Source of income and business judgment.
Who was it, a New York City case?
It was New York City case.
State Supreme Court? Or?
Bronx.
Oh, Bronx Supreme 2010? I think I might have that.
You know?
What was it, 2010, like recent?
Yeah, it's recent.
I think I might have that case, yeah.
So my thought on that was, this is what I was looking at, was how do we,
I mean, that's, I don't know if that's binding. It would guide us, it might not be binding
Well,
us.
that's fine, that's why, it does fine, that
Was that East
You have
187?
different wording, it's slightly different
Yeah.
wording than they have, and so that's what I was kind of looking to find out was, how do we, and is there a way that you can set up, I think it'd be a great idea to set up like the Department of State does, where you could issue like advisory opinions that would give us direction of what is reasonable business judgment and what is unreasonable business judgment. Because right now, we're kind of sitting in a quandary going, and I know you are too, in many ways, going,
That'd be interesting. I would be willing to do it. But
We're not just using the federal guidelines.
The extra work. I think I have that case here. Is that East 187th Street?
I did this when I first started reading this thing.
Yeah, it's a 2009 case. It's actually in landlord-tenant court. Interesting. So actually, you could go to landlord-tenant court with this, right? And enforce our law. The city court. Like Yonkers City Court can enforce our law. I don't know.
This was specifically say that the Human Rights
Speak.
Commission is subject to, it goes to the Human Rights Commission, not to landlord tenant. But that's a legal question. I got a specific, practical question, and that is, some people come to us who are getting some assistance from ESS, Department of Social Services.
Yeah.
But often it's limited, 3 months or for a year, that they're going to be getting, this assistance, and then after that, they're kind of on their own. So the assumption is they're going to get settled. But I'm looking at that and saying, wow, I'm only going to get guaranteed a year.
Yeah.
And after that, it's not like Section 8 that goes on and on and on. And basically, can I say, well, in my business judgment, that's not sufficient, because I'm looking for people who are going to live there for more than a year. And that's actually what happened.
Like a DSS voucher for housing or something?
Yeah, well.
Well, first of all, if that was the case, I guess, oh, no, the case, we'd have a case against you. We can't have a case against DSS, though.
No.
Because they're a county entity.
In terms of
Yeah.
my rejecting the client saying, they're only gonna, he says, okay, DSS is gonna pay my rent, but how long?
Yeah.
And usually there's a limitation on it, not like Section 8, it's not an ongoing commitment with a contract between me and a government agency.
You're saying it's not the source of income, it's the lack of income, not the source of income. It's
Right, right. And so the question is, if I reject them because of that, could I
Right.
be brought up on charges on this regulation?
I don't know, that's a good one. That's one of the best ones I've had.
That situation.
Yeah.
You can't, because it's the same scenario as if I had a job and I get $100,000 a year today, and I made an application and you rent the apartment because I have that income today, but in 3 months from now, I got paid off.
Well,
It's the same scenario.
let's say you said that. Let's say you said that the person came forward to us, right? We have to look at it. We may not, we're going to determine if we can file a complaint. But then in the course of our investigation or preliminary investigation, we uncovered that you did that again to a person, or you did that to, you didn't do that to someone who had that same problem for some other source. Or, you understand what I'm saying? In other words, you weren't consistent with that. That might show that you were really discriminating against the Section 8 guy.
If I consistently decide not to accept someone with limitation, like a 1-year limitation on the assistance, as long as I'm consistent, then that would hold a lot of weight. proceeding if somebody said you're discriminating against me on this law.
That's right along the crevice.
But as I say, it's one of those things that does happen here in Westchester.
Yeah.
So I think it's something we need to guide on. Yeah.
Anyone else?
And,
Alana Kelly, then Howard.
I just had a quick question. So my understanding under this law that the Human Rights Commission will get involved in some type of education on it or a seminar or something. Are you guys going to do that?
Yeah, this is it. Yeah, this is it.
That's it? You're not going to do anything else? Because I don't mean to be disrespectful, but it seems like this is a law, unfortunately, that has to unfold in order for us to figure out how you act and react. So for you to tell us this is it, I think it's only been in play in a month, and we'll wait to see who's going to get sued and how it's going to lay out, and then we should act accordingly. That's
Don't be the first.
Yeah, I mean, I don't know what more we would go over. I can't give you, there's certain things that are clear that I could give you my opinion on, I think, but other than going over the law, which we did, I could give another talk on how different courts have handled this kind of thing, but other than that, well, I could do that. I could do that.
I have another very practical.
Yeah, we could do it. Maybe I'll give a survey of different issues that have come up and how the courts have interpreted it. What I can't do is I can't get locked into certain. But I could do that.
If there's precedents, then we know how to act accordingly.
Yeah. So I could go over, set something up like that. Because that's what's going to guide me. The case law.
I know in some situations, we may have an apartment, and the rent is going to be higher than it's going to be in Section 8. And somebody asks us about an apartment, and we say, well, chances are Section 8 is not going to, they're not going to approve that amount of rent, because it doesn't, it's their guidelines.
Yeah.
And so we don't want to pursue it, it's a waste of time. And they bring us up on charges.
Yeah, from the cases that I've seen, that was like parallel to the kind of case I was talking about just a few minutes ago. Like I'm not so sure that's I think at the end of the day, a court might say that wasn't your call.
Okay, so
The administrator has to say.
go through the process with them.
Yeah.
But then in the meantime, so Section 8 always takes time. I may rent it to somebody else who's not on Section 8. I can say, I'll fill out the form, you go and ask them. In general, what we say is that go and ask your worker.
Yeah. Well, there's nothing in here, there's nothing in here that says, if a Section 8 person comes, presents himself and is qualified, all activities to rent out this apartment are state. You know what I'm saying? In other words, that's just not what it says.
So in other words, I can say, well, fill out the forms.
Yeah. Now let's say factually it came out that you were, a little magical email came down that said, I'm going to delay the process with CVR because I got another guy coming in and I don't want Section 8. A smoking gun like that.
Right, yeah.
Then that's something that we need to look at least look at.
Okay, 2 more questions. How we wrap it up? Mike Bellotti, then we have to wrap it up.
So, I know this is a little bit backwards, so forgive me, but if I'm a Section 8 voucher recipient, and I get, let's say, $1,000 a month towards my rent, do I identify that $12,000 a year on my taxes? Do I identify that as actual income?
I don't know. I don't do tax. I don't do.
But if I get a voucher for $1,000 a month towards rent, am I declaring that as income when I file taxes at the end of the year? And am I actually paying taxes on it? Because I'm just wondering, I know it's backwards, so forgive me for being late to the question. But is that actually income?
No, it's definitely not my expertise. It's bad tax. You'll see in tax law.
Mike, did you have a question, Michael? No? All right, anyone else? Everyone, please help me in thanking Mark Fang. And also, many thanks to Control Figure.
please join us on February 4th and February 13th. You'll get many more reminders from us. Thank you. Have a good evening.